Thank you very much, Valentina. We're going to go into the Q&A session. Darío Fajardo, doctor, he had to leave early, so I hope you can understand whoever wrote a question for him. Some of these questions are not going to be read. Some of them are going to be read, and they're going to be asked to the panel members still left here. So I have a question for Dr. Lucas. Three questions, actually. The first one is this question is related to Canadian companies in Colombia. They mention companies such as Anglo Gold, Ashanti Gran, Colombia Gold, companies with Canadian capital, which some of them are linked to opposition to restitution processes. The question is, citizens in Canada, do they know about their operations, the operation of these Canadian companies in Colombia? Do they know about the opposition that these companies are bringing forward to these activities, these restitution activities? It's surprising that there is Canadian jurisprudence. Even though there is Canadian jurisprudence, there are very similar things here in Colombia, but things that are not being respected related to our national Colombian jurisprudence. That's the first question. Another, the following question is related to in Canada. Have you been regressing in terms of exploitation policies, oil exploitation policies? Are you being less protective? Are you guaranteeing less things? Are you respecting rights less in Canada, especially speaking about indigenous communities? And some other questions try to get to this. Apart from the strategies, judicial strategies, indigenous in Canada, how are they getting their rights protected in your country? So I think these are the three questions that we want to go about first.
Do Canadians know about Canadian mining companies operating in Colombia? Actually, they do. Canadians are aware, though not as aware, in my opinion, as they should be, about the role that Canadian companies have in the global mining industry, not just in Colombia, but in many other parts of the world. Canadian companies have found themselves in trouble of one kind or another, either not complying with environmental standards of the host countries, finding themselves in awkward positions, let me put it that way, as far as indigenous peoples' issues are concerned. What they say and what what I think Canadians think they are doing is working in these countries to the same environmental and social standards as they would have to in Canada. Whether that is true or not, or the extent to which that is true, we don't really know. We hear about certain disputes, some of the mines that the questioner mentioned here in Colombia, several of the mines in Chile, mines in the Philippines have been problematic, mines operated by Canadian companies. So that's a general picture. Citizens know, but I'm not sure that Canadian citizens know everything they ought to know about the Canadian mining industry as a global mining industry and the way it operates in countries like Colombia. So with respect to the second question, maybe I've answered that already. Is Canadian law and policy regressing? becoming less protective. I think what I tried to show in my presentation is that some advances are being made, but the advances that are being made are being propelled more by judicial decisions based on constitutional rights than they are by government initiatives. However, in some of the provinces, in Alberta, for example, in British Columbia, those provinces have, in the last several years, come up with and implemented Aboriginal consultation policies that they developed in consultation with those Aboriginal groups concerned with resource development. So there are some things of that sort happening, but there is a change right now because for not quite 1 year, we have had a new government in Canada after 9 years of a very narrow-minded and internal-looking conservative government in the country that was really fixated on traditional economic development and not much concerned with the rights of Indigenous people and advancing those rights. So that has changed. There's been a major report of a Truth and Reconciliation Commission in Canada that looked at Aboriginal issues across the country, and they produced several hundred recommendations, all of which are being implemented by the federal government and to the extent necessary by the provinces. So there's been a political change that is very positive and will, in my opinion, at the very least, prevent Canada from regressing further on some of these issues. And the third question, to what extent are rights protected? Was it rights in addition to Indigenous rights? One of the major areas of activity in Canada has been on the environmental front, and that is the Conservative government that I mentioned, 9 years of a Conservative government that denied the idea of climate change. So needless to say, Canada did not make much progress on climate change and greenhouse gas emission reduction, the greater percentage of which in Canada comes from the oil and gas industry, and the larger percentage of that comes from the oil sands, that photograph that I showed you in northern Alberta. But since that time, all of the major provinces in Canada, including Alberta, where the oil sands are, have developed oil sands, new oil sands policies and new greenhouse gas policies that and legislation that have the effect of either implementing carbon taxes or putting a price on carbon in one form or another. And several of the provinces are moving ahead with carbon taxes as well. There's a big debate going on now about whether these two approaches are actually incompatible and whether these provinces need to get together on one policy approach or another. So that's an example, and success in that area really does have the effect ultimately on the ground of protecting local communities and Indigenous communities that are affected by major energy development.
Muchas gracias. Voy a abordar ahora unas preguntas que están hechas para todos los panelistas.
These questions are for all panel members. The first question is, what characteristics or features should a project have? Let's talk about Chocó. Let's talk about why you looked around the country and using the Canadian experience here. What features or characteristics should a project have so it's sustainable based on a transitional process to peace? I would like to say this again. Everything that we're talking about based on the first ethnic judgment, the state itself is acknowledging the visibility of the ethnic communities, and this was done with supporting ourselves on the Colombian legislation and supporting ourselves on judgments from the Inter-American Court of Law. So we are basing ourselves on this, and what we can say is that there is no articulation. Barbara Collin, I think, said this, and a lady from South Africa said this too. Before Law 14, before the ethnic decrease and the restitution law, what it's doing is that these laws should be cross-cutting when we are talking about development projects. When we talk about this from an environmental standpoint, what we're asking for, what the law is looking for when we talk about territorial rights, is that these rights should not be violated, but there should be coordination, there should be harmony, and there should be consolidation, because the environmental policy in Colombia is very clear. So rights should be visible. For the case of Chocó, this is a department, a province that is its territory, about 70 or 80% of its territory is part of Law 79. This is a reservation. We have a lot of vegetation. We have a very rainy area there. We have a strategic position. So our territory and our communities have special rights, and they have their own way to develop. This does not go against development. What we're asking for is harmony between the rights that we have and the development policies and the way we want to develop as a region. We are trying to get people to respect our territorial rights. We want coordination. We want harmony between the legal instruments and the way we want to grow, because our department is ethnic in nature. So when this is not considered, we see that there is no stability. The community says, I am invisible before the country. I have these rights, but some institutions in the government, they are denying that I have them. So as a territory, we are putting together this effort of calling upon the institutions so they live by the regulations, by the constitution, and on that basis they put together a development plan for the country, taking into consideration diversity of thought and diversity of ethnicity. As part of this framework of land restitution, this incentives that we give to people who want to go back to their land, they have to be associated to a territorial focus, specialized, or putting together a specialized productive model. In fact, this is being done by the Agrarian and Rural Office, but sometimes they put together initiatives that go against initiatives that the community has. So this sustainable development model has to do a lot with the particular conditions that every single territory has. But anyway, we have some elements like the administration of common goods. This is very good for agrarian communities. There has to be diversity. There has to be ecology has to be taken into consideration. Many things have to be taken into account. From a national standpoint, we have this instance for articulation, which is called the agrarian community consultation. Anyway, we had several instances podcast where we have talked about many issues, our food safety, food production. We have talked how every region could contribute to this based on their own processes. So I do believe that acknowledging what has been built already from every single territory, if we take that into consideration, we are going to be able to produce a sustainable development model. Sustainable in the sense that we have many common goods.
Series of factors, criteria that new resource projects should be able to meet. That is, projects that may adversely affect local and indigenous communities. I mean, first of all, those projects need to be environmentally sustainable. They need to meet all of the specific environmental requirements, have a full and complete environmental assessment, but ultimately they need to be environmentally sustainable. That's number one. Secondly, there has to be a full and complete consultation and participation process directed to the communities and people likely to be affected. And that has to address consultation and accommodation in relation to those projects. And maybe most important, it has to include the possibility that governments will say no to projects. They will conclude as a result of that process that they are simply too damaging, too intrusive. They should not be inflicted on local and indigenous communities, because too often the result of a consultation and accommodation process is simply some mitigation of one kind or another, and a report that issues concluding that, well, yes, there are impacts, but they can be successfully mitigated and the project should go ahead. And when the reality is that the impacts are going to be much more damaging than the final reports suggest. So some projects simply ought not to go ahead, and the process ought to include that possibility. There needs to be provision for compensation in the appropriate circumstances as well. There's a role for compensation. I think I showed in my presentation what that might perhaps be. What's the bottom line? In my opinion, the bottom line is that members of local communities, members of indigenous groups, ought to be able to say, when they look at a project, at a resource project that affects their lands, they ought to be able to say, on balance, we think we benefit from that project. Right? On balance, we think we benefit. If it meets that test, then that may be a reasonable standard to consider.
Una pregunta
Question for Valentina. I think this is very much related to the initial question for the panel. What's the relationship between the ecosystemic services and territorial right processes or land restitution processes?
A lot of communities, even though they understand the issue about those ecosystemic, on behalf of the green capitalism, basically is in regions where it's not polluted, so they pay for that purpose. But in other regions, they keep on having that matrix of energy mining that is depleting the environment. Nonetheless, understanding that contradiction is an economical alternative, assuming the role of environmental subjects who manages and takes care of the land. So beginning with these natural reserves of the civil society, let's say sustainable, or in the framework of protected areas, can be able to do with environmental focus that generates that economical sustainability. Of course, that is not the ideal because in the background is that contradictory issue and that role that is being led by many environmental organizations that have biopiracy and a lot of environmental issues. But what the communities, as long as I've seen in these protected areas, has been make good use of those resources and ecosystemic resources and services. For Professor Lucas, a clarifying question and an additional question. The clarifying question is about whether, I guess that is a question that unites the first and the second picture. If nowadays the subsoil or the minerals are property of the private owner or are property of the state, the minerals underground. And the second question is if the resistance that we are contemplated in Canada is mainly from the tribal population, the First Nations, or if there are other social ethnic groups that are joined in this, and how common is the resistance of the other social groups and how have been manifested?
To the first question, the government, the state, continues to own the subsoil. Although in Canada, there are some areas where private persons actually own the subsoil as a result of historic grants that were made by the government going back to the early 19th century. But by and large, the subsoil continues to be owned by the government. So the government leases out the mineral rights, and if a company goes ahead with drilling an oil or gas well, it has to get the permission of the surface owner, for which it must pay. So it must enter into a surface lease that would be negotiated with the surface owner. What if they can't agree? If they can't agree, the legislation that I mentioned provides for a reference to an arbitration tribunal. It's really a sort of minor court that decides on compensation. Here's evidence on the value of what's proposed and the cost of the harm that's likely to be caused, and makes a compensation award. So that's how that process works. In Canada, it's not just First Nations populations that have been concerned with resource development. It's residents of smaller communities, and there are a number of examples of small communities that have been affected by resource development. These would either not be indigenous communities, or they would be mixed communities of one kind or another. And there have certainly been issues of that kind in the country, and much of the debate has been around consultation and accommodation. But these discussions tend to take place at the provincial level, because, as I think I mentioned, it's the provinces that own the natural resources. So it's provincial resources and provincial agencies and provincial legislation that would govern in those situations. There have been a number of communities that have been affected by the operation of oil and gas facilities, of mines, where emissions are causing health problems, issues of that kind. And the federal government, as well as a number of the provinces, in my opinion at least, have been looking at these issues more carefully than they have been in the past, and in some cases at least imposing more rigorous requirements. But it's the First Nations push that has been the major issue in Canada. And I should mention that there are over 600 First Nations in Canada, okay? And they're all different. They all speak different languages. They all live in different places. So you cannot think about Indigenous people, just as is the case in Colombia, you can't think of Indigenous people as being sort of homogeneous, right? They're separate nations.
Yes. The questions that we already pick up are at least the ones that I get. We already answered. We have already 15 more minutes, so I want to get back the question to the public. Is there anything else you want to add? A final comment, a question? I just require you to make questions, not interventions. So if there is an inquiry, I want to clarify that Professor Darío Fajardo is not here, so not those questions because they were very specific about the Colombian conflict. My name is Germán Londoño. I belong to the Victims of Violence table, and I want just to confirm the extraordinary lecture of the woman of Chocó and the one who spoke about the indigenous resistance. Look, currently I'm someone benefit from a collective reparation in a land that we lost with the paramilitaries 25 years ago. The land El Levante was 600 hectares, was a form of Mancuso, and now through the direct action in a judge in second instance make a verdict in our favor, because the first one make a verdict in favor of the paramilitaries because the victimaries didn't recognize us as victims, and that situation is given in many places. I want to confirm this. The indigenous resistance and the Negritum resistance in this Minga shows the dynamic of the communities demanding the government the change of the economical model. The government cannot keep on insisting in not negotiating the armed conflict. The limitation that has the table in Havana is that the FARC wasn't allowed to expose that situation, and the communities have to have that in mind because they shed blood in this fight, and we are supporting the fight regarding that sense. So the question is, to what extent Santos Port is the one that once negotiated with Guerrilla for they to leave the lands where they operated for 50 years to now give a space of the biggest criminal invasion of the multinationals to get our natural resources? That would be the question. Thank you very much. Within the issues, that's why we say the harmonization of the public policy is being given with this process of restitution, because it cannot be invisible the environmental rights that already have the communities. The model, as we show in the first sentence, was assess the issue of the invasion, as you say, of the policy that is being moved forward of mega projects, but we are checking the importance of which lands are not making violations and in which lands there are being making violations to consolidate that. So we have to understand that it's not a criminal policy, because regarding some senses we are ignoring the progress of the policies. We have to have in mind that this is a different moment where the dialogues in Havana, they are also listening the victims. In this week the ethnical communities are traveling, and the land is not being taken off because the guerrillas are also harming, allowing actions that are degrading the environment due to economical sustainability of the conflict issue. So we have to enter to analyze two issues. Up to what extent we are moving forward to a construction policy of peace, where we are all listening to us, to ourselves, and trying to get the path to a development exercise, and up to what extent the force outside the law is being part of the destruction of the environment just for the economical sustainability of war. In the case of Chocó, the plantation, the cocaine plantation, the kitchens have destroyed the biodiversity, the rivers that are being polluted and affecting most of population. That has been due to the Atrato Apex is being taken advantage of illegal mining, exploitation, and is supported with the guerrilla, because everybody knows that a caterpillar, a bulldozer, is not going to enter in a department with so many conflicts and guerrillas, and that they are not going to pay. That is the model that they are willing to keep on having, to keep on depleting the environment, and that's what currently the resistance of Chocó is saying. We support the dialogues because that gives us peace of mind regarding living on the land, and the ecotouristic plan with Chocó would be the best window for the country, but it is not, because there is not an easiness in the department. The department is all the time in fear, where they are gathered with an insecurity and lack of food that is very big. For the department, the peace dialogues or the peace conversation is the best scenario, because at least at this moment there is a relative tranquility. Now, regarding the multinational, that's another issue that we are talking, because we require the development, but we also require with the acknowledgement of the landing rights already granted through the 1991 law. There are parallel agendas to the dialogues between the government and Las FARC. There are parallel agendas that are building different communities, and are shown in different scenarios like the Agrarian Summit and other different scenarios. So it seems to me that there are a lot of answers about how could we fill those emptiness left by those conversations, but also there are important progress, because the department unanimously support those agreements that post-conflict scenario, those changes and reconfiguration of the land, understanding the main contradiction linked to war. So there are some answers, there are some parallel agendas, and we have to acknowledge them. I want to thank the three members of the panel that we have left. And we have a butterfly also as member of the panel, three that are in this moment. Thank you very much for international perspectives, to show cases that could be successful, cases of different cases of resistance, local problems in a department like Chocó, problems and solutions in different parts of the country. And we conclude and close the panel of today. Thank you very much. Tomorrow, you are invited at 8 a.m.